allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Mr. Culberson, there are no postponement or withdrawal requests. No, sir. We have consideration for the approval of minutes, and just for everyone's knowledge, regular board adjustment participants are myself, Mr. Katz, Ms. Campbell, Mr. Johnson, and Mr. Robertson, with alternates that are Mr. Abraham, Mr. Brady, Mr. Hodgson, and Mr. Martin. Do we have has everyone had a chance to review the minutes, and do we have a motion to approve?
So moved.
Motion from Mr. Abraham. Second. And a second from Mr. Martin. All in favor?
Aye.
Any opposed? Thank you very much. Any old business, Mr. Culberson?
No, sir.
Any new business? Would we like to introduce our new member at this time or at the next?
Well, since we're there, that would be fine. So yes, sir.
Well, I'd like to introduce our new member, Mr. Kurt Hodgson, to the board, and I'd like to say welcome. Glad to have you serving with us, and if you would like to maybe give a brief introduction and summary of yourself, if you don't mind.
All right. I have just under 33 years of experience in local government. I retired. Kurt Hodgson, moved to Mooresville in March of 2018. I retired from Virginia Local Government Management after just under 33 years, the last as city manager of Harrisonburg, Virginia. Wasn't quite ready to give up local government altogether, and so applied for this board and was fortunate, blessed, privileged by the town board to appoint me. So I've got a wife, I've been married 37 years this year, 3 grown kids. My parenting may be in question. One lives in Seattle, one lives in Chicago, one lives in Washington, D.C. right now. So we worry a little bit about them, but they're doing well. So again, I appreciate the opportunity to be here and to work with each of you all moving forward.
Very pleased to have you. Thank you very much. With that, are there any administrative items, Mr. Culberson?
Mr. Chairman, item number 7A on your agenda, conditional zoning for 2221 Charlotte Highway has been removed from this agenda by the applicant. I would expect that it will be on your agenda in September. But you will just, that item will be removed from the agenda, so we will have the South Broad and the establishment of zoning on your agenda this evening.
Okay. I apologize, I was just going over the board adjustment. We'll move to motion to adjourn the board adjustment. There are no other questions or comments from the board. So moved.
Second.
All right, thank you very much. We'll close the board adjustment and we will open the planning board. We've got the postponement request that you suggested on the planning board, Mr. Culberson, Charlotte Highway. Withdrawal, I'm sorry.
Yes, that's correct.
Thank you. Has everyone had a chance to review the minutes from the planning board? And with that, do I have a motion to approve? Got a second?
Second.
All in favor?
Aye.
Aye. Any opposed? Thank you very much. Minutes are approved. Any old business, Mr. Culberson?
No, sir.
Then we'll move to new business, which Charlotte Highway has been withdrawn. So that will be 7D. which is DC 2020-21, 207 and 215 South Broad.
Thank you, Mr. Chairman and Board. This is a conventional rezoning request. Does not have a site plan attached to it. The applicant is Land South of MB Mooresville, LLC, for 207 South Broad, and Michael Ogden, 215 South Broad. The owner, both parcels is Land South of MB Mooresville, LLC. The request that's before you is a conventional request to rezone the properties from CMX corridor mixed use to town center. And you can see the map that the property is located on South Broad, just below McClellan, actually the corner of McClellan Avenue and Broad Street. The size of the property is 1.39 acres. Current use is on one of the buildings, they're both commercial buildings, one of them is vacant, the building on the corner does have occupancy. It is within the municipal limits. The district's for mixed use is the existing designation. The outright uses are duplex town multi-family medical treatment office, type 1 and 2 retail, brewery, restaurants without drive-through is the 8 attached and 12 units per acre for. And then the future land use, if you recall, a few months back, this board and the town board of commissioners extended the downtown center with regard to the land use designation to encompass properties actually between the downtown core and the mill. Downtown center in the land use plan says to encompass traditional downtown and serve as a civic and cultural hub and government hub for Mooresville. Primary uses are commercial, retail, and office. Desired density is 112 units an acre. You can see the properties in this map shown in proximity to the downtown center zoning or land use designation. This is 2 pages out of the one Mooresville plan. Shows the character and intent and the proposed uses, proposed density, and the opportunities for development in the downtown center. Another document that is referred to and referenced in this rezoning request is the downtown master plan. Downtown master plan, the little section was to redefine and refine Broad Street. It's currently the home to a number of private retail establishments and on its way to revitalizing its successful urban street. The downtown master plan calls for a mix of development, street level storefronts and sidewalk entrances. The next step for this request would be go before the town board at their September 8th meeting action. Subsequent to that approval of that zoning, there would be conceptual plans would be reviewed by town staff. Construction drawings would be reviewed by town staff. If necessary, land disturbance by Iowa County, and then building permits to facilitate uses by Iowa County. The staff recommendation is to approve this request to go from corridor mixed use to town center. The approval would be consistent with the one Mooresville plan. Town center is compatible with the downtown center land use designation and is compliant with the downtown master plan, which calls for commercial development on Broad Street. The TC zoning would help facilitate that. With that, Mr. Chairman, I'll take any questions for Kathleen.
Thank you, Mr. Culberson. Are there any questions from Mr. Culberson from the board?
Mr. Chairman, Mr. Culberson, the steps are line out here, just for general knowledge, are they looking to add and change buildings or just bring the buildings up to another scope? I know it's not part of this.
Right, our understanding is that you're going to have to use the buildings that are there now. The town center district will allow them for some additional uses and opportunities that they don't have in the CMX district.
One more question. The zoning that's there now, and the building is there now, have they paid any downtown taxes at this point, up to this point?
I do not believe so.
So by coming in, if we vote this tonight, and town board votes, then all those tax authorities will go to those buildings.
Well, my understanding, and this is something that we discussed when the One Mooresville plan was amended, is that tax district would also have, the boundaries of that tax district would need to be expanded as well. And there's some internal discussion about that, to extend it down to be complementary to where the council district is. So, as of today, the district doesn't extend that far, but,
So that's something we see as a further discussion of the town staff.
that's correct, to extending the downtown center, extending that tax district to be complementary to what that is.
Thank you.
Any other questions from the board? Mr. Culberson, is there an applicant to speak on this matter?
Yes, sir.
The applicant like to come forward, please? If you don't mind speaking closely to the mic as we're trying to record these, thank you very much.
I'll try, just let me know. Good evening, everyone. My name is Ben Casarino. I'm an attorney with an office in Davidson. I'm here representing the owner, like South End of Mooresville One LLC. And as Craig, eloquently summed up, this change in zoning is really allowing this property to have uses and design features more urban and more in line with the town center. To have the sidewalk entrances, to have zero, setback on the front streets, so we can have more connection to the pedestrian, and to allow those uses in the town center that gives it more of the urban feel. We believe it is consistent with the One Mooresville plan and the downtown master plan, and we cited various instances in our application that showed that. And in fact, this property was actually identified in both of those plans specifically as being one of the target properties for this type of use. So for those reasons, we believe that it's an appropriate request and will be consistent with all of the documents. I'm happy to answer any questions. I know you had a question earlier about the building, if there would be any changes to the building. We don't have any definitive plans right now today. The owner is exploring some tenancies, some potential users that would make changes to the facade of the tiered plaza building, and that would provide that more of that pedestrian feel and that walk-up feel. This will allow us to really pursue those tenants and be able to hopefully have a user occupant that would take advantage of those new avenues. Mr. Ogden is here as well on behalf of, he's a tenant of the 207 building, and his use would be more appropriate in the town center use as well. So those are the reasons why we're asking for the change. I'm happy to answer any other questions.
Thank you very much. Are there any additional questions from the board to the applicant? If not, then thank you very much.
Thank you.
Is there anyone here from the public to speak to this matter? Would you please come forward, state your name, and you have 3 minutes.
Thank you very much. My name is Paul Sharp, with my wife Catherine Sharp. We actually live at 251 South Broad, so we're in the blue house, it's just a couple of doors down. So we're obviously concerned about what's going to physically go in there. Just because of the amount of traffic that it brings to the area and what type of traffic. And I'll give a quick little story, and then I will concede my time. But we are definitely interested to find out more information. in the food kitchens down the street, we support it. We actually donate food to it quite a bit. But unfortunately, we had a homeless gentleman that decided to come into our patio the other night and knock on our back door after dark, and it scared us pretty bad, and it could have been a bad situation. So we've heard rumors that there's a bar slotted to go in there, and a straight up bar, and not just a beer lab. So we're concerned about the additional traffic and what type of traffic is going to be coming to the area. So I know that might not be determined yet, but we're obviously concerned about it. Thank you.
Thank you for your comments. Is there anyone else from the public to speak to this matter? Any additional discussion from the board? Any additional comment from staff? And with that, do we have a motion on the matter to approve or deny?
I'll make a motion to approve.
Do we have a second? Second. All in favor? Everyone speak clearly in the mic and raise their hand. Any opposed? That being stated, the motion carries. This board is board of recommendation. We'll be recommending to the town board to approve this on what day, Mr. Folks?
September 8th.
On September 8th.
And that is, I would like to point out, that is a Tuesday because the board's regular meeting is the first Monday of the month. The 7th is actually Labor Day, so that meeting historically and typically is moved to that Tuesday. So September 8th will be a Tuesday.
I believe that we have that in our packets. In your package, you find a statement of reasonableness on the matter.
Mr. Chairman, I go along with the affirmative motion that we have also approved the statement of reasonableness as listed on our guys. Need the whole thing?
Sorry,
Here, that's like. The zoning amendment is approved and is consistent with the town's comprehensive land use plan. It is reasonable and in the public interest because it would encourage commercial development and is consistent with the growth of the downtown area as indicated in the downtown master plan. The board has considered the zoning map amendment standards listed in section 2.3.1 of the zoning ordinance and finds that this rezoning meets all relevant standards. The downtown master plan lists Broad Street as a priority in terms of revitalization. This zoning amendment would allow elderly and logical development patterns consistent with the uses for a town center, such as office and retail space. The property is currently surrounded by commercial uses on 3 sides and does not contain wetlands or other environmentally sensitive features. Therefore, this rezoning should not have adverse impacts on nearby property values or on the environment.
Thank you very much, Mr. Abraham. Is that good from us, Ms. Austin? Thank you. Appreciate that. With that, we'll move to the next item, which is 7C, EZ 2020-07 for 245 Rocky River Road.
Thank you, Mr. Chairman. This part, the applicant is the town of Mooresville. The owner is Jordan T. and Peggy Merritt. The request is to establish zoning at single-family residential 2 or R2 from county residential RA or residential agricultural. You can see that the location of the property is on Rocky River Road in close proximity to subdivisions there. The property is 3.97 acres, location is 245 Rocky River Road. It currently has residential use. It is annexed to the town limits in June of 2020. There is a single-family home that was constructed on the property under county standard. The land use designation does the neighborhood residential. It's characterized by interconnected neighborhoods. higher intensity uses set apart from lower intensity uses. Primary uses are single family, townhome, duplex, triplex, quadplex, and small scale low-rise apartments. Desired density is 3 to 6 units an acre. And on the screen in your packet is a definition out of one Mooresville plan of the attributes of the neighborhood residential section. The next step in this project, in this establishment would be, it will go for town board action on Tuesday, September 8th. Staff does recommend approval of this request. The R2 is inconsistent with the one Mooresville plan, as it calls for 3 to 6 units an acre. The R2 allows 2 per acre. But having said that, this property and the properties around it are zoned R2 or R8 in the county, and the R2 district is the most compatible with the RA zoning district. So for that reason, the staff does recommend approval of establishment of zoning R2. And I'll take any questions that the board might have.
Thank you, Mr. Culberson. Are there any questions from the board, Mr. Culberson? If no questions, is there anyone from the audience to speak on this matter? Would you come forward, please, and state your name and address for the record?
My name is Courtney Garrigo. I'm looking at properties over by Rocky River. I'm looking to move to help take care of my mother. My question is, those roads are so narrow that when you are putting in more traffic, are they planning to widen the roads to accommodate for there to be more traffic?
Mr. Culberson could answer that question, but it's typically a traffic analysis matter, and that is normally covered in the analysis of the plan and the zoning about the capacity of the highways and what they can handle. And then normally we would ask for an additional traffic impact analysis if it's a concern with the amount of volume that's going to have. Please correct me, Mr. Culberson, if I'm mistaken.
You're doing fine.
All right, thank you very much.
You're very welcome. We appreciate your comments. Any additional discussion from the board or any other additional comments from staff? If not, then do I have a motion to approve or deny?
Better, let's go on. I move we accept.
Second.
We have a motion and a second, and we have a statement to read with this, Ms. Austin. And with that being stated, all in favor? Any opposed? Then the motion carries. And now we should have a statement of reasonableness that you could add to that, please.
It's approved and it's reasonable and in the public interest because it would be consistent with the current neighborhood and surrounding property zoning as it is surrounded by existing single-family residential homes and vacant land zone R2. Further, there is currently a single-family residential dwelling already located on the property. Given that the rezoning would allow development consistent with the surrounding area, it would not have an adverse effect on the property values in the area and simply continue the pattern of existing development in the area. In addition to approving the zoning amendment, this approval is also deemed an amendment to the town's comprehensive land use plan. The change in conditions the planning board has taken into account in recommending amendment to the zoning ordinance to meet the development needs of the community are as follows. The board takes into consideration that this area appears to be developing into a single-family residential area. Given the prior agricultural and rural nature of the area, transitioning to a R2 designation with a lower density than that of a neighborhood residential area, as contemplated by the One Mooresville plan, seems to provide a more logical and orderly development pattern to be more in keeping with the character of the surrounding area.
Thank you, Mr. Johnson. And commendation for a good voice kid. Good job on that. All right, with that, Mr. Culberson, any administrative, staff comments?
Just briefly, we are continuing to move forward with the UDO rewrite. There are some things that will be coming out shortly there with a website for that. There's also will be coming live shortly, and I encourage you to look at that. Staff put together a preference survey that you can take that deals with housing types, roadway types, open space types. There's a number of questions on there. One of the things we're looking at to elicit information from the public. We will also tentatively, depending on what happens between now and then with state regulations and things like that, we're tentatively scheduled to have a public forum kickoff for the UDO rewrite in this room, all three of these rooms, on September the 29th. There will be two sessions, one at 4 p.m. and one at 6, where we will be making a presentation for the public as far as where we are with the with the UDO moving forward. Prior to that, we will be receiving an updated outline from the consultant with proposed layouts and some of the things, and that information will be shared with the public. I would encourage you, if you're able to attend that as you folks at the steering committee. You will be, at your September meeting, you will be privy to that information prior to the public forum, and it will be there for your review and discussion. The other thing is hopefully in the near future, I'm really excited. We've actually got a new staff member that will be starting September 7th. We've got another planner that will be joining us in the Planning Community Development Department. Her name is Krista Jordan. She comes to us from Greenville, South Carolina. She is the landscape architect of the Park and Rec Division. If you've been to downtown Greenville, you know what a great place that is. So we're really excited about having her in. And at some point, we will decide when to have her baptized in front of you folks. So, and with that, Mr. Chairman, I think that's all the comments as far as we've got. But as what I'm happy to do right now is to turn planning board meeting over to Carrie Austin, our assistant town attorney. One of the things we've been talking about with the board over the last several months is training opportunities and things like that. So tonight, Ms. Austin's going to be talking about the statutory basis for your role and some specific items with regard to quasi-judicial hearings, and there will be a test. So, well, with that, I'll turn it over to Ms. Austin.
Well, thank you very much, and thank you, Ms. Austin.
Are you going to be able to hear me? Is that loud enough? Yes.
I can hear you clearly if everyone else can.
Great. I think that y'all must have made copies on the edge over here of my presentation. Someone did, it looks like. Is that correct?
Yeah.
So y'all might want to pass them down in case you want to take notes. You don't have to. Look at me blankly or respond. I appreciate your time. You all have already met me, and I've been on a few of your meetings, and you're going to see me probably at almost every meeting from here on out, so we'll get to know each other well. Tonight's going to be a primer for some of you and a refresher for others, but we are going to talk about, let's see, the planning board and board of adjustment, which is all of you. We have up here our municipal merry-go-round. These are all of our departments and committees and commissions, both appointed and staff and elected. And they're all interconnected, but they all have very different roles. And so we're going to focus our attention tonight just on you guys, the planning board and the board of adjustment. We will have to talk about the board of commissioners and the planning department a little bit, but we're going to mainly focus on you. So why are we here? Some of you serve on multiple boards, obviously, and it's really important to know and understand the difference and the effect of what you're hearing. And so one of the things I want you to know tonight is what are your duties as a board member, whether it's on the planning board or the board of adjustment, and to understand when you play a certain role, because you're gonna have to switch hats if you're having a hearing tonight as a planning board member, and you're also having a hearing as a board of adjustment member. It's a very different type of hearing. So I want you to be able to recognize those things and switch hats. It matters because both procedurally and practically, it uses our town resources and it protects our citizens' rights. And we're gonna talk much more about all of that. And by the end of this, I'm hoping you're gonna know what a conflict of interest is if you don't already. And I want you to be able to tell what competent evidence is and what it is not. Most importantly, what it is not. And then I don't want this to just be me talking and it going in one ear and out the other. I would hopefully hope that this is something you can turn into a plan. I want you to take information away tonight that you can think about before your board meeting and during it, and how you can be better individually and as a group. This one is a slide of all the different types of decisions, and you're gonna notice here that I didn't put the different boards that I had on my municipal merry-go-round up here under a particular type of decision. And that is because some boards hear more than one type of decision. For instance, the Board of Commissioners hear both legislative and quasi-judicial matters. And so, even within the same board, they might hear different types of decisions. We're gonna start way over there on the left-hand side with the administrative decisions. Basically, those are where our staff makes decisions, and they are applying ordinances to a specific set of facts. And it's non-discretionary in nature. So, they're granting permits, they're talking about violations, those sorts of things. Then we have our advisory opinions coming backward from the left, and that's you guys, the planning board. Those are decisions that are not binding, but that guide. And the people you're guiding are the Board of Commissioners, and the decisions they make are legislative in nature. And so, because you're advising a board that's making legislative decisions, you should pay attention to what I say about legislative decisions, because even though you're not quite as bound as they are by those, that's what you're guiding toward. So your advisory opinion is not binding, but it's basically legislative in nature, if it were binding. And you have some leeway as an advisory board and as the legislative decision. I'm going to skip over there to legislative. Those decisions have less restrictions, so to speak, with regard to procedure and evidence and all of those things, and even conflicts of interest. And it's because a legislative decision creates or amends a law. It's a policy that is applied townwide. It's going to be something that's broad and sweeping, and it's policy, so they need a lot of discretion when it comes to that. And so if a court were to review a challenge decision, their standard would be abuse of discretion, which is a pretty high standard to me. It means they would have had to do something pretty wrong to get overturned, if it's that standard. However, if you're making a quasi-judicial decision, and that's what our Board of Adjustment does. Everything that our Board of Adjustment hears, both administrative appeals and variances, are quasi-judicial in nature. Quasi-judicial just means you sit like a court. And so, because of that, you have a lot of strict procedural rules that are in place. And they do not set law like a legislative decision does. This is applying law. So this is where you take a specific set of facts, you take an existing ordinance, and you apply it. And so even if you don't like the ordinance, even if you think it's a bad ordinance, it's not your job to change it. If you're on a quasi-judicial panel, your job is to apply it. Now, you know us lawyers love to talk about slippery slopes, so I couldn't resist this little cartoon talking about they want a variance for a mountain in their backyard so they can ski. And they tell them that, sorry, but if we allow that, it's going to start us down a slippery slope. And they say, well, I think that's a yes. And I think a lot of times that's what people out here hear we may say one thing, but they hear another. And so part of what we have procedurally and practically is to avoid confusion. And it's to be consistent with decisions. And it's to avoid challenges and to avoid being overturned. It's all of those things. Practically speaking, sloppy procedure leads to challenges. And usually our challenges to any decisions that the town board makes would be because either we lack authority, that would be a challenge, or because we didn't use proper procedure. And either one of those things can be brought as a challenge. The reason for the procedure is that it protects our citizens. They have due process rights. And these things that we have to do, like giving public notice of meetings, allowing folks to attend, having an impartial decision maker, all of those things go to a person's due process rights. Those are constitutional rights of our citizens that we protect by abiding by those strict procedures. The planning board, so this is all of you. You're reviewing and advising, that's your job. And because you're advising the Board of Commissioners, like I said, it's an advisory board, but it's a lot like a legislative function. As the planning board, your decisions are not binding, but they do guide. You may hear public opinion, as we did tonight, and you're not constrained by the rules of evidence. Even so, it's wise to make your decision based on reasonable things and in the public's best interest. Those are sort of the standards. And as you make those decisions, one of the reasons we do statements of reasonableness is because you need to communicate the reasons for your decision to the Board of Commissioners so that they know why you think it's reasonable and why you think it's practical or in the public interest. And that's a good opportunity to do that. So, the last thing here is the conflict of interest standard. Those of you on the planning board, all of you, if you have a direct, substantial, or readily identifiable financial interest in the matter at hand, you have to disclose it, and you have to either recuse yourself, or if you're not sure if it's a substantial, identifiable interest, you can bring it up to the board and they can vote. But that is the standard for conflict of interest for you guys, and it's also the same standard for our Board of Commissioners. We've talked about statements of reasonableness or not, even if a vote is no on something. It's really, again, you're an advisory committee, so you want to advise the Board of Commissioners on why you don't think an item is reasonable or in the public's best interest, or why it is. So this is your opportunity to do that. So I encourage you to make sure that you're thinking about your statements of reasonableness and how you're communicating to the board at large. Moving on to the Board of Adjustment. This is where things get a little more difficult because quasi-judicial hearings are more constrained. Yes?
So, state the reason. Normally, when we're stating is reasonable, we're written. This is the conundrum. Nobody's, the state of reasonable is subdivision. Nobody's against the subdivision. Okay, so it's reasonable with the plan, that's good. It's reasonable with the layout, whatever zoning, that's good. What most people have concerns about is the impact beyond just that piece of property. And so we say it's conducive with the plan, well, that's reasonable. But as our person said earlier, well, how's the traffic? Is it reasonable for traffic? Is it reasonable for the input that the stranger's going to put on your school? That's where most people's statement of reasonableness comes into, that we never really touch on. And that's what most people's issues are. That's what the planning board issue is. It's not that, is that house reasonable? Does it look pretty? Though we want that. It's really how's it going to affect our quality of life and quality. Are we going to end up being Matthews with a two-way road and at 5 o'clock it's 1 mile down long, just like the River Highway? Are we going to be 3 miles of backed up traffic because the stable reasonable subdivision is fine, but now we got all this traffic and the infrastructure is not made to handle, and that's unreasonable. But we have no way, in my opinion, to say, this is unreasonable because we have no clue what the impact's gonna be on the highways once this thing's developed. We got 5 more subdivisions coming right behind it.
Not sure.
I'd be happy to address that if you'd like. I'll come up there so you can hear me on the mic since we're broadcasting. So, very good question. You notice this month's packet is a little bit different in the staff report. We have zoning map amendment standards, section 2.3.18 of the zoning ordinance has that list that is in your staff report for each of these rezonings, a list of 10 items that ties directly into larger impacts than just the specific parcel, because it does tie into those greater community impacts of what a rezoning will actually do. That is something, please, when you're looking at these, we are rewriting, of course, the Unified Development Ordinance. So if there are other things we need to be considering with rezonings that you feel would help you make a decision and provide good guidance to the town board, please let us know and we can include those in our rewrite and ensure that the standards that you are looking at and providing guidance on will help ensure the greater community will not be adversely impacted by approvals.
I saw that. I thought that was helpful. At least I kind of saw the decision-making process. But also at the same time, I guess the question is, what is the criteria? We say, well, it won't impact traffic. Is traffic to you 50 cars a second, or is it 2 cars a minute? You know, so that's another criteria. And I don't get that deep in the weeds, but I'm saying from a reasonable standpoint, that's what I want to be able to do, is to say, reasonably say, yeah, I like that development, but as they said, it's going to put 5,000 cars on there, every car every second. This is a neighborhood, and that's not what we want.
And that's why the legislative approvals are so broad, because it does take into subjective items that you cannot put in black and white. Because where is the threshold of too much traffic? That's not something you can say it is this number, because that varies depending on the situation, which ties into the statement of reasonableness. If you explain why it's too much traffic, you don't need the number 50, right, as your number, because it varies from the community, which part of the community you're looking at. So that helps provide information to the town board, where if you feel like a development would have a negative impact for whatever reason, and that reason is included in your statement of reasonableness, then that is information the town board can consider. Otherwise, they would not know that that is why the denial was recommended or the approval.
On that note, I will say that the trainings we're setting up, one of the ones that's going to be coming to you very quickly because you asked for it, is we're going to have our transportation folks come and talk about a traffic study, what's the TIA, what we can and can't require of folks. But that will help the context of your question.
I know a lot of times can't require anything. I understand that.
Well, and I think that your question goes directly to the difference between legislative and quasi-judicial that I was just talking about. That broad discretion we're talking about with legislative decisions, that's exactly what it is. You may think something's reasonable that I do not think is reasonable. And that's what that discussion period is about. You can bring up any of those things in a legislative or on the planning board, which is an advisory board. In those opportunities, that kind of discussion is allowed and encouraged. Because you don't have to base it on substantial evidence like we're going to talk about with the quasi-judicial. So legislative decisions like rezonings that affect the community as a whole are meant to have broad discretion. You as a board are meant to have that and have those reasons set forth for the bigger board so that they can discuss that. I would also mention, and you all correct me if I'm wrong from planning because I am new, that you can make approvals and condition them. You know, you can say I'm a little worried about X, Y, or Z in this, and so let's approve this, but I would only vote for an approval if we say that they have to do X, Y, or Z, you know, if that's a case. Now, your decision is not binding, but the board can make approvals with conditions
Absolutely.
attached.
Part of your recommendation to the town board can be proposed conditions for them to consider. Your job is not to just hand them a yes or no based on what's in here. if you feel that there's a condition that they need to consider, now, the one we did tonight, you can't because it's a conventional. Anytime there is a conditional rezoning, in addition to the staff report, the plan, all those things, EIA, if there's a condition, maybe it's a drive-through, you say, well, I don't think it, I'm okay with the drive-through, but I think it ought to close at 11, as opposed to being open 24/7, because it's next to a neighborhood. You certainly, as part of your recommendation to the board, can include conditions for them to consider.
So, I'm gonna go ahead and move forward to the Board of Adjustment. These are quasi-judicial, these are more restrictive. Unlike what we just talked about with the broad discretion, these decisions, are very different. The planning, the Board of Adjustment decisions, unlike the planning board, one, they are binding decisions. So these decisions will take effect and will have an impact on whoever the applicant is. But again, as I said earlier, if you don't like an ordinance, you can't change it as a Board of Adjustment, you can only apply it. So as we get ready to go through the quasi-judicial piece of this, I thought it would be good to go through some of the differences. As one of your first questions ought to be, is what I'm hearing legislative or quasi-judicial in nature? Because that tells you which hat you wear. Number one, the speakers are different. In a legislative forum, the public is allowed to speak, and they can say whatever they want to, as far as their opinion goes on the matter. But in a quasi-judicial setting, you're gonna have sworn witnesses, and they have to have standing. We'll talk a little bit about what that means. But there's only certain people who are really allowed or have a right to participate. The evidence that's required in a legislative hearing is really, there is none. You can hear opinion, you want to make sure it's reasonable in the public interest, but you don't have to see fact. I don't have to hand you an expert testimony. I can tell you what I think, and you can consider that. But in a quasi-judicial decision, you need to base your decision on competent, substantial, and material evidence. You cannot base it on lay opinion or hearsay or any of those things. The voting for both is a simple majority in most cases. However, in the case of a variance, which we heard by the Board of Adjustment, that requires a four-fifths vote. And we'll talk a lot about variances and why that four-fifths vote is required instead of a simple majority. The legislative decisions will establish standards. They make ordinances, they amend ordinances. Quasi-judicial simply applies it. And the conflict of interest standard, this is different, so pay attention to this one. If you have a financial interest, that's what disqualifies you on the planning board. But on the Board of Adjustment, it's much more. A personal bias, ex parte communications, or any financial interest in the outcome, doesn't have to be substantial, and any close, familiar, business, or other relationship that might be affected by the decision. So this is much broader conflict standard.
Sorry, would you mind going back?
What?
Would you mind going back real quick? I just want to make sure, are there any questions on this? This is a lot of information about differences, and I wanted to make sure before moving forward.
Yeah, please stop me if you have any questions.
Last comment that you made on we all have a lot of relationships with people in the community.
Mm-hmm.
The decision, the way that was stated, what you said, the last thing, the impact of that decision would influence the relationship I had with that person. Is that what you're saying?
That the decision, well, a close, familiar business or other relationship with an affected person. So if that decision would have an impact, not necessarily on the relationship.
On my relationship.
It's if you have a relationship with a person who is going to be impacted by that decision. Let's say there's a 7-Eleven going in and it's going in right next to your mom's and she doesn't like that. And, you don't like that either, you might want to disclose that. That's probably a conflict of interest, because she's going to be affected by that decision. Or if your daughter is slated to be the new manager at that 7-Eleven, and if it doesn't go in, she's not gonna have that job. That's definitely a close familial relationship that's gonna be affected by that decision. Anything like that, yes, would have to be disclosed. Now, some conflicts that are questionable and some aren't, and we'll talk a little bit more about that as we get into conflict of interest, but yes, those things ought to always be disclosed. If it's a question in your mind, it ought to be disclosed, at a minimum. I'm ahead of myself in my notes. All right, so I've already told you that this is to protect the rights of our citizens. The procedure part of this, which is sometimes burdensome, I know, but it is to ensure impartiality. It's to ensure that the evidence that we base our decisions on is competent and to meet the requirements of transparency that we have by statute. But before a hearing begins, if a member believes he or she has a conflict of interest, it should be disclosed. Again, it's the financial impact, bias, and let me go a little bit further with bias. Bias means that you have a predetermined opinion that is not susceptible to change. So if you think that Joe Schmo, who's wanting to do something, is a no good somebody, and he's never gonna come through as the contractor on this, and you can't get rid of that idea in your head no matter what, is that a bias? If it's not going to change, then that's probably a bias, depending on what it is, depending on why you think that, but those are things that would be considered bias. And of course, the close family relationship. Ex parte communications, anything outside of the hearing, and this includes not just being contacted by an applicant, but it's also, you cannot have ex parte communications with other board members about the upcoming agenda item and the decision that's going to be made, other property owners. It really just should not be with anybody. There are some things that you can do, like site visits, and we'll go a little bit more into that in a little bit, but if you do those things, like a site visit, we ask that you do that through a staff member, and that you do not speak to any neighbors or the landowner, and that once you come to the board meeting, that you disclose that you did have a site visit and what you saw there, if it might impact somebody's vote. So those are, the main thing I want you to take away from this conflict of interest thing is, if you're in doubt, disclose. If in doubt, disclose. If you know that you need to recuse yourself, then recuse yourself. But if you don't know, disclose, and then the board will vote as to whether they believe it's a conflict of interest or not. And if they vote yes, then you would be asked to withdraw from the discussion and the vote. So anytime there's a conflict of interest on these, you would not only not be allowed to participate in the vote, but you're also not allowed to participate in the discussion. And you will actually be asked to leave the room during the discussion and vote of that agenda item. When it comes to evidence, we want to make sure that everything is substantial, competent, and material evidence, because we want our facts to be supported and our decision to be supported. And what I want you to think of is that a third party, a court who has to review your decision, has to know why you made your decision. They're not here. They don't hear everything you hear, and they don't see everything you see. So when you make your decision, and we'll talk more about findings of fact, but that's what you're doing, is you're making it so that a third party, whether it be just a third party or a court who might be reviewing a challenge decision, can know what you based your decision upon.
Can I clarify a little bit on that? The example you gave was really easy for everybody to figure out. Let me give you this example. Let's say if a gentleman comes in here and he cuts my grass each week. He wants to build a 7-Eleven, but his outcome on that 7-Eleven does not affect my relationship with him cutting my grass. Would that be impartial?
I think that, again, if in doubt, disclose and say, I think I can be completely impartial on this, but if you guys don't think I can, then take a vote on it. But if you don't think that it would affect your decision, then no. If you don't meet any of the other criteria, then no.
And if I could throw in, I would say it's better to disclose.
Yes, always disclose.
Because the risk is if you don't say he cuts your grass, that could be something that comes up later.
Yes, I should have made that a slide, the if in doubt, disclose. I don't know why I didn't think of that, but that is true. If in doubt, disclose. And disclosing doesn't always mean you're going to recuse yourself, like I said. It may be that you say that, and then everybody says that's not a big deal. Lay opinion and conjecture are not evidence, and they can't have a bearing on your decision in a quasi-judicial setting. And transparency extends not only to giving proper notice, but also setting forth a clear basis for your decision, which we talked about already. Okay, so before the hearing is made, we've talked about no ex parte communication. And here's some practical things. What if somebody approaches you before they're up for hearing? Then my suggestion to you is to refer them to staff members, to talk to them about whatever issue it is, and not to engage in a conversation about a matter that might be on their agenda. If it does occur, you need to disclose it. If you've been receiving a bunch of emails from somebody, or somebody's been stopping you and talking to you about that, again, when in doubt, disclose. You need to, if it hasn't made you biased, or if it hasn't been something where you've talked about and gotten evidence outside of the hearing, then it's probably okay, but you still need to disclose it. And we talked about this already, about the site visit being permissible, but only in certain situations, and that you need to disclose that it happened, and anything else that you noticed about the site that might impact somebody else's decision. Before you come to a hearing, it would be great if you could review the preliminary record and consider what facts might support or not your decision. You want to think about what questions you might ask the applicant or the owner of the property, and give thought to what findings might be necessary to support a decision one way or the other. Of course, you want to keep an open mind because new evidence may be presented, but we do get a lot of information prior to the meeting, and it's a good thing to review that and have some idea of what facts maybe that you need to know to make a decision. Because sometimes there are things like you're talking about that you want to ask about traffic or neighboring properties or whatever the case may be. So y'all been asking me a lot of questions, so here's one for you guys. We have a hypothetical. Goober owns a small gas station in town and is serving on the town planning board. Recently, Gomer Pyle returned, having made it big with his singing career. Remembering his happy days at the local filling station, he invested in a large gas convenience store chain. Gomer has applied for a rezoning so that the new 10-pump station can be built only 2 miles from Goober's current gas station. Goober is concerned about how this might affect his business. Does Goober have to disclose his ownership of the gas station as a potential conflict of interest?
He needs to call Barney.
Well, I think the first thing you need to ask is, what type of decision is this? Is it a legislative decision or is it a quasi-judicial decision? Because the conflict standard is different.
This is a planning board recommendation rather than a quasi-judicial.
Yes, it is. It is asking for a change in an ordinance. So it is not applying one, it's asking for a change, and it's legislative in nature. I think personally that he needs to disclose it. And if in doubt, disclose. And he would have a substantial readily identifiable financial interest, and that is the standard for a conflict under the legislative model. So he should recuse himself. If Gomer says, well, golly, I just trust old Goober to be fair, can Goober participate in discussion or the vote?
I'd be under the board.
No, he can't. The conflict still exists and he cannot waive it. What if Goober is going out of business? And he's already put it in the papers, and he's going out of business like the next day, and says he thinks he can be fair. He discloses it and thinks he can be fair. What do you think?
It would seem he's put a line in the sand, but it's still, it could have bias, if he knew that was coming and it was part of why he made his business decision.
Right. So this is a closer case. This is the case where I think if Goober thinks, I can be fair, but he needs to disclose it, so he does, and then it's up to the board to say what you just said and to discuss it and take a vote. So that would be the close call, I think.
All we get would just be rough, because in the natural, them two are close.
Yes, they are. They have a relationship, and that relationship is also perhaps a conflict of interest that ought to be disclosed. Let's move on to hypothetical 2. Mr. Briscoe Darling has received several citations for violating the overgrown grass ordinance, and he has ignored them and has mounting fines. Mr. Darling now applies for a permit to build a small studio building on his property, the same property, for his family band to use for practicing and recording music. Given his chronic violations and non-payment, the planning department denies his permit application. Mr. Darling files an appeal to the Board of Adjustment. Before the meeting, Mr. Darling sees a board member at Goober's gas station pumping gas. He runs over yelling about the planning department's cornbread and tells the board member that he needs this thing to be set right if he's ever going to get his daughter Charlene out of his house. Fearing Mr. Briscoe has cornbread issues of his own, the board member quickly finishes and moves along with a smile and a wave. What issues do you see? Well, the first question we ask is what type of decision is it? Is it legislative or quasi-judicial?
Well, this is moving to a quasi-judicial, so
it is in fact a quasi-judicial decision because it is a variance, or, sorry, it's an appeal of an administrative decision, I'm sorry. But that still is a quasi-judicial decision. And so what is the conflict of interest standard there?
well, I would certainly disclose it if I was approached, period.
That's correct. But again, we have not just a financial interest, the conflict of interest for a quasi-judicial decision includes bias, it includes the family contacts and things of that nature, it includes ex parte communications. So we're going to look at all of those things and say, well, this was an ex parte communication, it should be disclosed, but it's probably not to the standard that's going to disqualify anybody, because there wasn't a large discussion or anything like that. The other part of this would be bias. If the board member is worried about his cornbread, Mr. Briscoe's cornbread, then he has to ask himself, can I be an impartial decision maker? And likely he can. And if that's the case, he doesn't need to say anything. But if he doubts himself, maybe that's a possibility. So we talked about before, now during the hearing. During the hearing, there's still preliminary matters. We talked about the fact that in a quasi-judicial setting, the public can't, they don't have a right to participate and cross-examine witnesses, present evidence, object to partiality, all of those things. Only parties with standing may do those things. And so at the beginning of a quasi-judicial hearing, we have to establish standing. Some people have standing by their presence, the local government, for instance. We have standing in the matter. The party has standing, the property owner has standing. A neighbor doesn't necessarily have standing. They would have to show a substantial, I'm sorry. I'm losing myself. Suffer special damages. If they can give evidence and show that they have suffered special damages or would suffer special damages, then they perhaps might have standing, but there would have to be a standing determination made for that sort of person who is not a party or a property owner of something that's at stake. Before the hearing begins, there also needs to be a determination about whether there are any conflicts of interest. So you'll hear the chairs ask, does anybody have a conflict of interest that they want to disclose or they need to recuse or withdraw? Or does anybody know of one? And so not only could you say that about another board member, let's say that somebody should disclose and they forget to, or they don't, and you feel like they ought to, then you can bring that up. Also, a party can bring it up. If they know that that guy cuts your grass, then they might say, I'm gonna challenge him on his partiality, and I want the board, before this hearing ever starts, to vote on whether he should be a decision maker for this matter or not. So a party can challenge, or a board member can challenge. As we get further into the process, you each need to know how to play your part. The chair, you act as the judge. You make procedural rulings. If someone objects, you have to sustain it or not. If somebody is giving repetitious testimony or irrelevant testimony, you need to rein them in and put a stop to that. If they're giving hearsay evidence or lay opinion when it's not allowed, you can either stop it or you can make a statement that that was hearsay evidence, and the board cannot consider that for their decision and remind them of that. So you sort of serve in the judge role. You're all judges in that you're making the decision, but you're the judge as the chairperson as far as the decorum of the room and the procedure of the room. As members, you can ask questions of the witnesses at any time during an evidentiary hearing. Always state your vote for the record, even if you've seconded a motion. That's one thing we've talked about before as a board, is that even if you second something, you need to make sure you vote. The parties have the right to present evidence, to cross-examine witnesses, to inspect documents, and to make objections. Non-party witnesses may also be a part of the evidentiary hearing. These are people who don't have standing to be a party, but might be called as a witness for some reason or another. Those people, again, don't have the same rights as a party does, that they cannot cross-examine or make objections and that sort of thing. And we've already talked about the limitations on repetitive and irrelevant testimony. So moving on to the evidence that's presented during the hearing. During the hearing, evidence will be presented, but all evidence is not competent evidence. All evidence is not credible evidence. And the cartoon up there is a little right. State's evidence has to abide by all of the rules of evidentiary procedure, that sort of thing. You are constrained in that you can't rely on hearsay and lay opinion and that sort of thing, but all of the strict rules that are in the courtroom do not apply to you. But a few are very important and do apply. So you just need to be mindful of what evidence is and what it is not.
If we're hearing the evidence, typically I'm assuming this needs to be a subject matter expert, just like when we're talking about traffic. If someone says, well, you're gonna run over my children in the street, you're bringing too many cars on this road. Again, we hear that, but we have to go by whatever the traffic expert tells us relative to, this road, accepts this many cars per day, this many trip generation, it's built to this standard. Again, that's out of our specialty or our spec or, again, our level of knowledge about that. So we have to trust what they're telling us. I'm assuming someone's giving evidence, it has to be someone to that same skill.
Well, on certain matters, yes. Not on every matter, but on certain matters, yes. And you're hitting on the part that there is by statute. You cannot hear lay testimony on things like traffic, how the increase in vehicular traffic is going to cause a public danger. You cannot hear lay testimony on how the use of one property is going to affect the value of another property, or any other matter that an expert would be required to give the testimony on. And I would think things like environmental impact, things of that nature. Now, you will also get evidence from witnesses who tell you that this is what I saw, this is what I've experienced. That's evidence. That's perhaps very competent and credible evidence, but it can't be about those things I just listed, if that makes sense. And again, that distinction that you just made, something you hear often about, well, there's just going to be this increase in traffic. That's something you can hear in the legislative side, and you can base your opinion on part of that if you think that's reasonable. But in a quasi-judicial setting, when you're on the Board of Adjustment hearing a quasi-judicial matter, that cannot be the basis of your decision. Somebody's lay opinion that traffic's going to get worse and my property values are going to go down. Now, if they bring in a traffic expert to give that evidence and you base your decision on that evidence, that's different. That's competent evidence. What evidence is not is an uneducated, is an educated guess or intuition. It's not what you heard from your neighbor. It's not any of those things we just talked about by law about property values and vehicular traffic and all that stuff. And if we ever do need, if an expert is brought in by a party to give testimony in that fashion, we would need to qualify that person as an expert. Somebody getting up from the audience and saying, well, I am a medical doctor, and I believe that the exhaust from those cars is going to wreak havoc with that entire street. Well, is he an expert? No, not in the legal sense. He might be, but we need to go through the process. There's a process for determining whether he is an expert or not. And is he an expert in the lungs? Because that's what he's testifying about, and he might be a foot doctor, for all we know. So there's a process for determining what is this person's education, what are their qualifications, have we determined that they in fact are an expert in this field or not, so that we don't have people just willy-nilly saying, well, I'm an expert, I'm going to do my testimony.
I have a question.
Yes.
So assuming, for this basically we'll talk about the variance anyhow. So if we have a variance coming up and somebody's against it and they talk to you, the planning department, whatever, do y'all prime them, for lack of a better word, say, if you're gonna come give evidence or you're gonna come speak against it, you need to be sure you have evidence and supportable, not just, I don't like it, it's gonna look ugly. Because then that's a good way to head off some of this stuff that we don't have to deal with, some emotional issues, if it's handled up front when people are calling or complaining. I deal with it all the time, so that's what I'm just asking. Also, to dovetail on that, do you educate people? Because it's tough for us, we're like that, situation where you stand out there pumping gas and somebody comes up and says, Mark, I want, and they start unloading and talking to you. They might not know the rules either. Do we try to educate, when they fill out that form and answer those questions, do we have a section where they read and say they can't talk to us at all and then sign it? Shouldn't that be in there? I've always wondered why we don't have something where they read that and sign it, that they cannot talk to us.
Well, in the application, it explains that they're not necessarily signing it, it's kind of like terms of service. They're not signing that they read and understand that. The other thing that we do to try to help you folks is, they have to turn that application in at least a month ahead. Whenever we get one, Jackie sends an email to all you folks so that you know this is coming, so that if a guy does come up to you and say, hey, you're aware and you can cut that off. But we do, you know, when we meet with an applicant that's applying for a variance, we do explain all that to them now that,
Yeah.
once they walk out the door, whether they adhere to that or not is something we can't.
I'm not really concerned about the applicant. I mean, the applicant applying, I mean, I guess that's what it is, but I'm speaking in terms of somebody, just the public who's coming in and they have something to say about it. And we always say, this is quasi-judicial. I can stay up for 20 years, I don't use that term. But for them, if we're developing a notice saying, hey, this is there, if you want to say something, be sure you have support or some type of evidence based, not a term like I'm worried about traffic being bad.
Yeah, well, and when, I know that at least in my experience, I've asked other folks in the department to do this. If we get a call from somebody about a variance that I don't like it, then I typically tell them, here's the findings that the board has to approve in order to grant the variance. And if you're going to speak against it, you need to look at these and you need to provide evidence to one or more of those that shows why the variance doesn't meet that standard, not just, I don't like it because it's gonna be traffic. Now, you know, when they come, they may around, but anytime I get a call from someone, just, you know, in an effort to be fair, I you know, I say you need to, you know, just like it's incumbent on the applicant to prove to you that you can say yes to the finding. Somebody, now, the other part of it is if they've got standing, you know, they have to have standing to be able to even stand up and say that they're against it. But they're under the same burden to give you evidence that will lead you to say, well, maybe they don't meet this one or whatever.
And Steve has, in his introduction now, a very big explanation of what the hearing is going to be about. And at the start of a variance hearing, for instance, he will reiterate that these are the things that must be proven and shown. Now, it obviously is great for them to have that before they ever step in here, and the planning department probably does a good job of trying to do that. But as to the question about like at the gas pump, even if you told somebody face to face, you're not supposed to talk to somebody, there's nothing we can do to prevent them from doing that, and there's lots of folks we know who would do that even if they know that they are not supposed to. And so in that situation, it is incumbent upon you, if you know I shouldn't be talking about this, to stop them and say, you need to go talk to the planning department, or I cannot discuss this with you, and just be as respectful as you can, but you cannot do that, you cannot participate in those conversations.
So if we have someone come up in the audience to speak to the matter, we swear them in, and they start talking about something again, just like you mentioned earlier, the doctor that wants to comment on something about breathing. Do we ask them at that point what their level of qualifications are? Do I approach that with them at that time? And then if we hear a qualification that doesn't meet what standard for what testimony they're giving, do we stop that testimony at that time? I may be a little cloudy on how to handle that situation.
Yeah, we'll cover maybe a little more, but I'll just jump to it. If somebody wants to present expert testimony, then yes, they should qualify them. And if they start to present that testimony and we realize that that's what they're trying to do, it is absolutely appropriate for you to say, would you like to be qualified as an expert? And to go through that process to see if they actually can qualify as an expert witness, and you have the script to do that. So that is absolutely appropriate if somebody is trying to give that type of testimony. Now, I'm gonna separate that a little bit from somebody who's called that person up specifically to bring evidence, who is a party, versus somebody from the audience who wants to get up and speak. At a quasi-judicial hearing, we are not required to allow public comment. We can allow it, but we don't have to. If you decide as a board to allow public comment, then it has to be done in a non-discriminatory manner. Meaning, if you can't give one person 3 minutes and another 12. If you're gonna say it's a 3-minute time limit, then that's for everybody. If you're going to, say, well, I like her, but I don't like her, that's discriminatory. You can't say, well, we're gonna just allow 2, because I see the first 2 people that I like and nobody else. So if you're gonna allow that, that's fine. And they do have to still be sworn in, because that's the rules. But you have to be non-discriminatory. That's the main thing to keep in mind there. The other thing to keep in mind is that allowing public comment in a quasi-judicial hearing can make things a bit confusing for the reasons we've been talking about this whole time. And that is because you cannot base a quasi-judicial decision on a lay opinion. And most of what you're gonna get in the public comment section is going to be lay opinion. Not say that it all will be, but you're gonna get a lot of that, and if that happens, it would be incumbent upon you as the chair to either say, we've already heard this, it was repetitive, or to say, I want to remind the board that any lay opinion we hear, we cannot rely on, and hearsay evidence, if they start talking about what their neighbor told them and that sort of thing.
But we have the right as a board to work with our commission and say, we don't want to allow public to speak. And so, in my years and so forth on this, I think public speaking in a quasi-judicial act is wrong. It's just wrong. And I don't think we should put ourselves out there to allow it at that point. I mean, if you can judge that they're a standing party, okay, it's public, but I just think it's a bad deal for us to consider the public comment during a quasi-judicial, because it does lend itself to be confusing, and I think it's just something we shouldn't put ourselves out there.
I like your thoughts on that. I like keeping it concise so that the evidence presented, everything is clear, because I look at us as a juror sitting there. Again, you're supposed to hear something, you're supposed to be siloed until you hear the evidence and then make a judgment based on the evidence so that it's made very clear and concise.
And that is absolutely something that's up to the board to decide. And of course, in your role as planning board, you're going to allow that public opinion. Whether or not it's sworn testimony, that's advisory, it's legislative in nature, and it's allowed there. But in the quasi-judicial, if you find that it's confusing or not appropriate, it certainly is not required. We've already gone through what all of this is that's up on there right now, what evidence is not, it's not speculation. And I want to make sure that you understand that hearsay is not just statements of what my neighbor told me, but it's also writings that were not done by the person in present. If I come to you with something that, well, I got writings from 5 of my neighbors, I've got letters from all of them, but none of them are here, then that's hearsay. It's not my firsthand knowledge, okay? So that's also hearsay. And the things we talked about with vehicular traffic and property values and expert testimony, that's all by statute, and that's the site for it right there, 168.
So unless it were testimony from the applicant or documents presented by the applicant, then outside of that would be hearsay and not be
Right,
for consideration.
it's not firsthand.
I think too, even if the applicant, the person requesting the variance or the purpose of the quasi-judicial hearing, I think even though they are the applicant, I think you can still hold them to the standard of expert testimony. Just because they're the applicant
Absolutely.
doesn't give them the ability to sit up there and start talking about traffic is or isn't.
But hearsay and opinion are 2 different things.
Right.
So but yes, I mean, expert testimony is only from an expert. Hearsay is firsthand knowledge. They're 2 different things.
The person withstanding, I'm talking about homeowner, like, if they say, well, we have this expert who would like to present, then they can do that because it's an expert addressing some part of the variance.
Yes, yes. All right, we're here to our hypothetical. I feel like it probably could have come a little bit earlier because you all are on it. with your questions. Ernest T. Bass has heard that axe throwing has become a popular business and thinks that rock throwing could catch on as well. He owns property in a commercial zoning district but needs to build a structure to protect neighboring properties from the rocks being thrown and the shattering glass. He realizes he would need a variance on the setback provisions to make this happen. At the Board of Adjustment hearing on the matter, Aunt B asked to speak. Since everyone loves Aunt B, she is allowed to speak in opposition to the variance. She states that her bridge club meets in the coffee shop next door twice per week, and this new rock throwing business will not only be noisy, but she has heard from Clara Edwards that this new sport attracts city characters. And it's a safety concern. When Ernest T. tries to ask Aunt B a question, the chair tells him to sit himself down. What issues do you see?
She doesn't have standing, I would think, and it's hearsay.
There we go. First of all, we start with what is it? Is it a quasi-judicial or a legislative decision? It's easy. Quasi-judicial. Because we're looking to change the law. We're looking to apply the law to a specific set of facts. We're not looking to make law or change it. There's no conflict of interest question here that I can see, but we do have the standing issue with Aunt B. Is she somebody with standing? Is she a party? Is she an owner of the property at issue?
No.
Does she suffer special damages? In her mind, probably yes. Her bridge club is important to her. But is that special damages? No, it is not.
But the restaurant owner fell on her behalf, because he wants to have them at his bridge club, so he would be the property person. Won't say that would mess up because my clients enjoy the coffee shop.
Well, is his opinion based on the use of another property is going to affect the value of mine?
Well, I'm thinking, I see, said you can't prove that it's from her.
That's lay opinion on a matter that's statutory.
So you have to prove that somehow it's going to harm his business.
Well, he would have to bring evidence of special damages.
What they
And he would
said
have to bring
is
competent
that,
evidence of special damages.
So-
Things like, so for instance, let me give you a first instance. So if I'm a property owner and I think that let's say even my property value is going to be drastically hurt, and that's substantial. I'm gonna be substantially harmed by the building of whatever's happening next door. I can't come and give you lay testimony on that, but I can get a real estate broker or a real estate specialist who's gonna do a comparable study and put that in a writing and come to you and present it and show you what damages I might sustain from the building of that versus what I have now. And if I do that and you consider it special damages, then I have standing.
okay, let me ask you this. I'm talking about the coffee shop? I'm talking about the coffee shop.
Coffee shop next door.
So you got that loud noise. Now, I don't know how somebody can go around and do compensate whether the loud noise here is going to affect this coffee shop. I mean, I don't see that. It may be possible, but I don't know. But if Aunt B came in and said, well, our bridge club's not going to be here, and your other customer said, we're not going to be here anymore, would that not be enough to just say,
What
hey,
would that
my
be?
clientele said they're going to leave, they got to listen to all that noise.
Well, what would that be, hearsay?
Well, then I guess he could bring them all in. And they'd all say, yes, we're leaving, yes, we're leaving, yes, we're leaving, yes, we're leaving.
Well, they could, but,
Well, I
She
mean, you
had-
can't get much more
no,
expert
I'm
than
gonna
somebody saying
back
they're
up.
leaving. I'm playing that.
I'm gonna back up because
Well, he can say.
what he's saying is hearsay. What's saying, well, they are telling me that they're going to leave, that's hearsay. But can he even bring that? Can he produce standing first? That's the first question, is does he have standing? And
Can he
he has
say-
to produce evidence of his special damages before he has the standing to bring them up as witnesses.
Let's say that Page Group generates some revenue to his place, $20,000 a year, and they walk away, he's going to lose revenue of $20,000 a year. It's proven that their business is bringing that kind of revenue to him. Isn't that a way for him to show that
If
it's
he can
damaged?
show that. But I think that it's getting a little bit in the weeds now, but at the same time,
And so I think you can reject or approve the variance, but you're not gonna change the use. So you don't let them encroach into the setback, but you still potentially could get the use of the property.
But I think that you have to kind of go a step beyond and say, how does he prove to you that his business is going to be harmed? Well, one, you have to think about what the business is. You have to have a business expert that would probably bring that kind of information to you, because just because they're bringing in significant revenue and it may leave, it hasn't left, it may leave, there may be others that take their place. Will the rock throwing and the glass shattering be how noisy will that be? Have you brought in an expert to say if that's going to be a violation of noise ordinances? And would it be heard within the walls of his coffee shop while the windows are closed and the doors are closed? I mean, all of those are questions that an expert would need to answer. And so we very easily get into what we're talking about with hearsay and lay opinion. Your sympathies are in the right spot, but sympathies have no place in making decisions about does this person have standing or not? Does that make sense? You
I
have
understand
to
standing.
have the special damages. You have to be able to prove them.
Well, I would think without a doubt, the coffee shop owner has standing because he's next door to the side street, so he has standing.
Being next door does not give you standing. Absolutely does not.
So, wait a minute, then why do you send out letters as being next door to something that's being changed has no standing?
Because they are entitled by due process to notice.
Okay.
And just like people here in the public, they are entitled to attend, but they are not entitled necessarily to speak. So our due process rights are different in different situations. And being next door to someone does not give you standing in a quasi-judicial forum. It gives you, now, if you're having a rezoning done, and it's a legislative matter, and you're a next door neighbor, you can absolutely get up and speak. But in a variance issue, unless you have special damages, and the statute is very clear on this, being next door and, that's not enough.
Okay, so those gotta have show some kind of harm.
Yes.
Okay.
If you have somebody that is an expert, how do they get to get up and speak? They are an expert, they have to apply to the planning board or something for the meeting, if
Well,
they are an expert?
Usually that would be up to the party, the applicant or, whoever is before the board who does have standing to bring that expert. That's usually how an expert would come. I know we've talked about somebody just getting up from the audience, but that would be an unusual case. That would be a presentation of evidence. And so just like in a courtroom, if your attorney wants to put expert testimony on, it's the party who brings that expert to the stand. And that would be similar to this. And even though we don't have a witness stand per se, other than this one, that's the way a hearing should work, is that the party comes up, they present their evidence, and they may say, and I have an expert that I would like to call. Or they may say, I would like to call Mr. Culberson back up, and I would like to cross-examine him on some of the things he said. And they are absolutely within their rights to do that. That brings us back to our Aunt B situation. Aunt B got up and she did not have standing, but they liked her and they let her stand up. Now, could they have done that had they decided to have a public comment section? Yes. They could have allowed her, but they would have had to do it in a non-discriminatory way and allowed other people to speak. Was the chair right in telling Ernest T. Bass to sit down because he wanted to ask Aunt B a question? No, it was not. Ernest T. Bass, as a party with standing, has the right to cross-examine. He has the right to inspect documents that are presented. He has the right to object. And he should not have been told to sit down.
So he's handling that on the presentation level. He can call that witness, or he can question that witness rather from the example you just gave.
Yes.
One more question. So we had this kind of come up about some people that have some goats in the backyard. So the question becomes, the next door neighbor's working on the plan that I know of, but somebody who lived 4 or 5 houses down the way. So the question is, well, would this standing not exist? It's such like a neighborhood, so if somebody 3 blocks away somehow or another here runs downhill. And, they said, well, I live next to the house, but I'm 4 or 5 blocks down the way, and all the dirt they wash out comes to me. You may not even be notified, but that person have standing. You just have to come and say, I have standing because I can prove that dirt runs downhill and goes right through my yard.
We'd have to prove special damages.
So, I mean, so.
So yeah, it depends on, that's the standard, is can you prove special damages?
Yeah, okay.
If you're not the applicant or the property owner, and you're not the local government, then pretty much you have to show some sort of special damages that
So
you're
it's
gonna
not
be.
really whether you're next door or not, it's whether you can show damage.
Yeah, you could, I mean,
Okay.
you know, if something is built in a community and it's gonna affect that community, and I can show that and prove it, you know, if I can get a study on the house values now versus what it's gonna be after this thing is built, and I'm, you know, down the street, if I can show that, it's still standing.
Because no, we just think in terms of what's next door, like, oh, well, you're not next door, so you don't have standing, that may or may not be the case, what they're saying.
Right, that alone never gives you standing
Okay.
in the quasi judicial setting.
What level of evidence does the applicant need? Because I'm trying to remember all the applicants that come from up with us, to present their case. They don't have a list or a line of experts, they just make their case. I mean, you can shoot that down real quick, you don't have any experts to
Evidence
justify
doesn't-
what you're asking for.
Evidence doesn't have to be expert evidence, you know,
What-
when we're
what-
saying opinion evidence has to be expert, basically.
So he can say whatever he wants as the app, or he or she as the applicant.
Well,
They don't have a standard they have to reach.
you're confusing standing with, the standing is, do you have the right to object, participate in the hearing, as in, are you able to present evidence, cross-examine, and object? That's standing. That's your right to be up here and to speak in a quasi-judicial hearing. Now, evidence is what you present. And if you're going to give opinion on something, and you're not an expert, even if you're the applicant, your opinion cannot be relied upon unless you're an expert. So we're just talking about expert in the terms of opinion evidence. But there's other types of evidence. There's evidence of, the zoning is R2 on this, and there's evidence of that because of the zoning map. That's evidence, because I've presented you an exhibit that shows you that fact, and I've proven to you that fact by the presentation of evidence. I've told you what I'm going to plan on doing with my concept plan or whatever else. There's various things that are evidence. It's not that an expert needs to give you every piece of evidence that you receive. It's that opinion evidence has to be expert evidence.
So when an expert speaks, that's on fact. The expert has to stand up and say, okay, this case or she is factual.
Well, it holds more weight. Whether it's fact or not is your determination. As we talk about in every variance opinion and all of these, and even in the administrative appeals, you will make a finding of fact. And we're going to get into that shortly. But it is up to you to determine what evidence is credible, what is believable or not, just like a judge. So evidence is presented from both sides. You have to determine which evidence is credible, which is competent, which is substantial, what really supports the decision. That's your job as the decision maker, to make that call. We're going to move on to voting, and we'll come back if y'all still have other questions, but do you have to rely on precedent in making a decision? No, you do not. Unlike a court, you do not have to rely on your past decisions to make future decisions. And in fact, I would say it is not a good reason to make a decision that, well, we did a similar thing 3 years ago in that neighborhood, let's just do this. That's not basing your decision on evidence. That's basing your decision on, well, we did that before. Now, if you're making a decision and you've decided a similar case in a different fashion, then you ought to have reasons of why you're deciding this one differently. But just the fact that you did that in the past is not a good reason to make that decision. Majority vote is what's needed on most things, we've already talked about that. But variances require a 4/5 vote, and the reason is, this is very important, a variance is asking for you to take an existing ordinance and say that it doesn't apply to this one person. And so you're saying this law applies to everybody else, but not this person. And because of that, it's got very strict requirements, and they should be rarely granted, because that ordinance is supposed to apply to everybody. And because of that, they're requiring that supermajority 4/5 vote. Only final decisions can be appealed. That's pretty standard. The standard of review, the board must make its own independent determination and applying the ordinance and deference. Just because the planning board says that somebody's appealing their decision, do you have to listen to the planning board? No. Just because they've said X or Y and decided X or Y doesn't mean you have to. Though, you should give some deference to, or at least take into consideration that these are professionals and they have made some judgments, and take that into consideration. But do you have to defer to it? No. We're going to come back to variances again because this is a big one. It's a powerful tool, but it is not a substitute for a zoning amendment. Again, this is where we're saying a variance is the law exists, and this one person, it should not apply to for a specific reason. So if we have a group of neighbors who all have the same problem, for instance, that's probably not good fodder for a variance. That's something that needs an ordinance change, which is something the Board of Adjustment doesn't do. That's a matter for our Board of Commissioners. So this where it comes in, you've heard me say several times tonight, just because you don't like a law or an ordinance, just because you think it's dumb, just because you think it doesn't make sense or is unreasonable, that doesn't give you the power to change it. The Board of Adjustment's job is to apply the ordinance, not to change it. And in the case of a variance, it's to say the application, the strict application of this ordinance would cause a hardship for this person. And there's a list of reasons that we're going to go through as to why that is, and they're up here. Strict application of it would cause an undue hardship, not a mere inconvenience, not just it's going to cost them a little more money. It's an undue hardship. Number two, the hardship came about from the conditions peculiar to that property. Again, if there's 8 neighbors with the same property problem, perhaps this is not something peculiar to that single property. Usually it's got something to do with the location, topography, something of that nature as to why this particular hardship exists. Number 3, the hardship did not result from the actions of the applicant or the owner. If you made a bad decision in the past that has now made you regret your decision and you have to have a variance in order to do what you want to do, then you took part in making that hardship. So you have to show that it's not because of your fault. And the last one is that it's consistent with the spirit, purpose, and intent of the ordinance, and public safety and substantial justice would be achieved through the variance. If any one of those 4 things is not present, you cannot grant the variance. Now, if you get to number 1 and you say, there's no undue hardship, don't stop your analysis there just because you said no to 1. Yes, the variance won't be granted if number 1 is not there, but let's say they challenge your decision. Maybe number 2 is not there either. So you're going to go through all 4 of these criteria, whether they're yes or whether they're no, because it creates a record. Does that make sense to everybody? We want to create a record. We want things on the record so that if a decision is challenged, and this ever goes to, Superior Court where the Board of Adjustment, appeals are taken, that the court can look back at the record and see each one of these things were considered, each one of these things were decided. The burden of proof for a variance is on the applicant. So they must come in here and show you that all of those 4 things exist. That's their burden. All right. Up here are 2 different examples of findings of fact. One is a decent one, the other is not. Look at that second one, that smaller one over there to my left. And tell me why that is not a good finding of fact. And remember, the court says that simply discussing something and then making a decision and reciting the statutory reason is not a finding of fact, and that's conclusory. So you want to make specific findings of fact so that a third party can know what you based your decision on. Why is one good and one is not? The first one over here talks about the hexagonal shape of the lot. So there's something peculiar about this property, right? And we stated that in the finding of facts. And we've said that no matter where we place it, it's going to have a problem with setbacks. So there's no way we can strictly apply this ordinance and allow them to have a valuable use of their property. That's a hardship. Our statement, our finding of fact says that. Our second one over there says, basically, it's going to cost them $500 if we don't do this. Is that a hardship? It could be, but you haven't given me enough there to know that it's a hardship. You haven't given me anything in there that tells me what's peculiar about this property that they can't meet the setback. You have to tell me in your findings what supports your decision that those 4 things were yeses in your mind. And that second one doesn't do it. Now, don't get scared of this finding of facts, because I'm going to be the one that gets the pleasure of writing these. But you're going to have to give me enough in your discussion and in your talks as you hear these things to make these findings of fact. These findings of fact might sound redundant, they might sound tedious, but this is what a court would need to look at in the record to know what you based your decision on. So if we were to go through those requirements for a variance, let's assume, this is just the finding of facts portion, this is not the decision that was made, but let's assume that the decision was made that this variance is approved. Do we have statements in these findings of fact that support that? The first one is that there's no necessary hardship, that it's not a mere inconvenience. I can look at number 4, number 7, and number 8, and all 3 of those statements support, those are facts that support that this is an undue hardship. If the hardship results from conditions peculiar to the property, number 3 does that. Because it tells us there's wetlands. That's something peculiar to this property. The hardship is not due to the actions of our applicant or the owner. Numbers 2 and number 6 do that. It tells us about the governmental agencies who made these rules, and that's not her doing. Number 4 is that it's consistent with the spirit and purpose of this ordinance, and that public safety is secured and justice is accomplished. And numbers 9 and 10 do that. They tell us that we have considered whether the fire trucks and the other things can get through there, and is it gonna hamper the property values, and we decided it's not. So we have all of these things in there in our findings. And that seems probably like, oh, of course she lives at such and such. But nobody, a third party doesn't know, of course she lives at such and such, and of course she needs to have the setback. You have to make those findings. And just discussing them, as we talked about, discussing it is not making a finding, because Mitch can have one idea about what the fact is, and you disagree with them, and y'all are discussing it, and who knows what you based your decision on, whether Steve agreed with Mitch or you. Who did he agree with? So you as a board have to come up with these findings and know what you've done. You can't just say, well, we discussed it, now let's move on. You have to say what your findings are. This is my danger slide. We're sometimes asked, where does common sense fit into all this? And I'm sure you've thought that several times as we've been talking and going through hypotheticals and examples. And what I would say to you is not that common sense doesn't play a part. What I would say to you is that common sense dictates that to be effective as a board, you have to follow the rules. Common sense dictates that if you don't follow those rules, you're going to waste the town's resources, your decisions are going to be challenged, and they're going to potentially be overturned. So we are nearing the finish line. Your decisions are important. Even the non-binding ones are important. But especially those binding ones, because they're going to be around for generations maybe. So make good decisions, make procedurally sound decisions. And if you have questions, I'm always here to try to find an answer for you. And if you have questions, go ahead if you have one. But I'm sure we're all tired. I thank y'all for your attention and time.
Well, Carrie, on behalf of the board, we appreciate this and again, appreciate having you here just, as you have been recently, for the sounding block, just so that we can ask some questions and have a little bit better understanding before we enter some of these matters.
I'll say one thing and then I'll shut up so we don't go on. Mark, I think you asked the question really that's at the core of a variance case when you asked about the applicant say anything. I think the thing to think about is a lot of times, just like you said, an applicant comes in here and they basically state what they want. I want to add 10 feet to my deck and the ordinance says I can't. Is there anywhere in there where they gave you evidence to be able to say yes to those findings? As Carrie said, it might make her, oh yeah, there's nobody on either side, who cares? But you're saying it's okay for this one person to not abide by the law just because they want to. So I think it's very important for you, to ask, because as the slide said, the burden of proof is on the applicant to show why you can say yes to all 4 of those findings. And if they come in here and don't do that for you, then you're not under any obligation to go, it's okay.
And I'll piggyback. I think it's important to remember the zoning ordinance is a law. It's no different than saying, is it okay that I could drive 95 miles an hour through a school zone? Right? There needs to be a reason why that's okay. And that's up to you to decide. The zoning ordinance is a law. It's not because we think it's nice. It is a law which has the same power of every other law in the town.
Yeah, I would piggyback on what Greg said. It's not that you just don't have an obligation to, it's that you must deny. If one of those 4 things are not met, you must deny. Those things are required by statute. So.
There's an example that just keeps ringing in my head about several, on that
someone purchased with a concrete patio in the back and now they want to close it. That patio, they purchased the house, but it encroaches into the setback. But it's common for the whole community. So as I'm hearing that, what I'm hearing today is the Board of Adjustment should never be permitted because of patios in that situation because they, it's, even though it's common, we would be allowing them to break the law. I hear you.
No, you shouldn't. If there's not a reason for it, you shouldn't be allowing it to happen. I mean, if you bought something that's pre-existing, then you're not asking for permission, so you wouldn't be probably coming in to ask for variance. Unless it was a.
The patio is not encroaching.
The patio, but now they want to expand by
Right,
enclosing.
they want to
Okay.
Until they put the roof on.
choose to add an addition onto their home into the setback.
Within
Like, we
this,
had several where the patio was put in by the developer, and we got these posted saying, we really need to kind of look at that rule. We should make the builders, if you're gonna put a patio in, it needs to be within the setback requirements in case a guy wants to put a roof over it and close it as a screened-in porch. Because that's what happened on those cases, several of them, that the patio was there, they bought the house, and now they want to put a roof over it and close it and screen it. Well, it became a variance problem.
So they want to voluntarily, by choice.
they're coming to ask to build an enclosure within the footprint of that patio that already is encroaching.
But do
Into
they
the
have
setback.
is the setback rate a hardship?
The hardship, that was where I would start with.
They're
It's the
choosing
hardship.
to improve their property for their
How do you
benefit,
find hardship? You know, I can't sit in the
For
sun.
their
Not a
benefit,
mirror
for their benefit.
which I would argue does not meet any of the four criteria of the variance.
You know, it's true. We were being nice,
I would say that probably.
but we're not, because we're nice different. Well, it's just one subdivision.
Well, and I would think too, but
We approved it, but we probably didn't see that in court, but the ones we don't, when we start turning these down, we better dot all the i's, cross all the t's, because that's the ones that will sue us and go back
well,
out.
Well, and I will say, it is not just the ones you're turning down, because if you say yes to this one, and you didn't cross your i's and dot your t's, and then you decide to cross your i's and dot your t's, which you should, you go back and say, well, what separates this property from this property? And it is a slippery slope, where it would have been fine if it was one sign in 1 yard, and now you've got 12 signs in 12 yards, and it looks terrible, or whatever, but this really is an issue that is important, because that's why the 4/5 vote, that's a statutory requirement. By North Carolina statutes, they require a 4/5 vote on variances. And all of those requirements are under North Carolina statute. These are not even just municipal legislation. This is North Carolina statute that says if any one of these 4 criteria are not met, then you must deny.
I think burden is a very appropriate word for variance, because it should be and is a burden to bring you a case that you should be able to say yes to. It should be extremely difficult to get a variance granted. I mean, there should be some physical uniqueness or something like that. That subdivision, all those folks bought those houses, did they check to see if they could enclose it beforehand? Maybe they did, maybe they didn't. But the fact that they didn't do that doesn't change the fact that the law is what it is. You know, and if it's an inconvenience, that, you know, that may not rise to the level of needing right text amendment that we decrease the setbacks. But I think it is a burden for somebody to come in here and give you enough evidence to grant a variance.
The best example I've seen in my career is a triangular piece of property that you could not physically build on due to setbacks. Right? They could do absolutely nothing with their property that received a variance legally, justifiably, because they wanted to build one single family home on it. And it was placed to minimize the setback loss.
And they're trying to stay consistent with the other homes in the neighborhood.
Yes.
Let me ask you something, because I don't think it's gonna happen that much today. I mean, when I deal with a lot of course are bad lots, and I deal with buffers, so I deal with bad lots, where people come and buy these bad lots or slopes and that kind of stuff.
but in newer kind of development, as you go around looking at it, do y'all try to, from the plan standpoint, well, that lot's not buildable now, so let's don't even get rid of that lot or divide that lot so it doesn't become a variance issue at a later date because it becomes a hardship because we allow it to be laid out that way.
So a lot shouldn't be subdivided to be unbuildable?
Well, or it should be, the development should be laid out, then there's the goal to stay in the middle. And you can't be, because of setbacks, you can't build anywhere, so now you're coming in here and say, hey, I have a hardship, I bought this lot, but it's a gully. And the first question is, why is it there in the first place? It shouldn't be a lot, it should have been absorbed into the community area, or, and a lot of that happens, or to the adjacent lots, so it's just a little bit larger lot, a little bit larger lot, it's not 3 lots.
I mean, moving forward, new subdivision plats, should not be an issue.
Yeah, that's what I mean, said, I would
It's the older ones that are remnant from something that happened in 1940.
Yeah, that's what I would assume that would happen.
I mean, I think everybody in that, those couple of subdivisions that we had,
Well, for about 8 or 9 of the people come forward and want to build a screen porch on their cement slab they have now, their patio that they have in place. I mean, technically,
I guess what I was saying there, if you've got a whole street of lots that are exactly the same, they got a porch or they got a patio that's legal, but when you try to enclose it, there's an encroachment. First of all, as far as the variance goes, there's nothing unique about any of those parcels. So, you're gonna have a tough time proving that you've got a unique characteristic that's not existent in the rest of the neighborhood. And we've actually talked about that, there needs, one of the things that we talked about in the deal is there a maximum percentage that you can fill of the building envelope initially, so that you leave the ability to do something like that? Not necessarily next to make to reduce the setbacks, so all these folks can have a porch, because they lost their situation.
with my job, I've had to deal with some developments back in the day, the early 2000s, called the 24% impervious school. They would calculate to the dime the 24% impervious, and then I'd have the HO call and say, well, this person wants to put a patio, or they want to put a shed in the back. I said, they can't do it. I said, yeah, that's the developer messing them up because they can't do anything but sell what was actually built, and they were stuck with that footprint that they bought. They couldn't do anything else.
Well, I would even say in a case like that, Alan, their own action was purchasing that situation. That is their own action. They look at the plat and say, okay, you get a house and a driveway, you're done. Don't come in 5 years and tell me you want a shed.
Yeah.
To me,
I would
that is.
encourage y'all as a board, the thing that I would love to see is just giving more thought to why you are going to say yes to each one of those things. For instance, that situation, you would have to state a reason why that is an undue hardship. So I need for each of you to be thinking about that as variances, for instance, come before you. Is what facts am I seeing in this application that will support me saying yes or no to that?
We have to have very.
You have to have a reason that is stated, and it has to make sense. Or else it's gonna be very easy to return. So hopefully it's just going to make you think more about each one of those things, and you have to make a statement.
Well, just like you were talking, like Mark was alluding to, then it goes a can of worms, for future.
I think we'll have to turn over that.
Well, I think you're.
We want to get tough with it, means stay with the whole word tough, stay within the focus, let's go. If we're going to probably have to turn, is this on the record, we're having a meeting?
We're still You're not saying anything that's wrong though, Mark. It should, like I said, it should be extremely difficult for somebody to walk in here and get a variance granted.
We haven't made that, I'm gonna be honest, we haven't made that difficult
It
sometimes.
should be rarely, because it's a saying that
It
the
should be
existing law
very-
doesn't apply to this single person.
It
if you're applying the standards, it should be extremely difficult for somebody to come in here and get you to say yes. And if you turn down every single variance for the next 5 years, as long as you've done it by the standard, if they don't bring you evidence, there is nothing, you've done nothing wrong except do your duty to say no.
I don't think there may be one or two situations that we should approve. If you want to, I mean, I'm not trying to bias anybody's mind, but when you think about what we've done in the past, I don't even think a couple of them bounced out at me that we really should have approved and, you know.
I think it's something that's either it's been a mistake that was overlooked, you know, when someone went back again to do something on that property, and let's just say there was a survey and it made find it was overlooked and there was a setback issue, and we're looking to correct that. If they'll sell the home, whatever, you know, then they're not gonna understand it. That was a mistake, got overlooked by inspectors.
Without a few up with that.
That's right. You know, that's taking care of the person. They should be able to sell that home. You know, the variance protects their right to do that. You know, and I think we're doing, you know, fundamental, the spirit of what that is put in place to do for the homeowner property. But otherwise, this, you know, just the fact that I want the porch or I want a covering, but yet I bought this home where I couldn't do that, you know, I may only have to put, you know, a chair and an umbrella, because that's all it allows. It doesn't allow for a roof line that goes over the setback.
And I did real quick want to mention about recusal. So you'll note at the Board of Adjustments, there's 5 members and 4 alternates, right? There's a reason for that. Recusing yourself is not bad. So I know that, you know, no one ever wants to step off, but there's a reason there's so many alternates for the Board of Adjustments. It assumes you will need to recuse yourself. Just want to make sure that that's clear.
And one thing I did not say that I meant to, about public comment, so we're kind of going back to legislative. If there's a moment of public comment, I said that the board can ask questions during the quasi-judicial hearing when people are presenting evidence. If you have a question, you're free to ask them that at any time, and that's true. But when there's public comment going on, that is for the public to comment, and they might direct something toward a particular, they might say, Danny, blah, 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 and try to engage you. You should not engage with them. That is a time for them to make comment, not a time for discussion among the board, or between the board and a member of the public. So I just mentioned that because it could very well happen. I'm sure it has happened in the past. I'm sure it will happen in the future. But those are instances where you have to be the one not to engage. And that's what I forgot to say that when I was up there.
Okay, well, thanks very much. Is there any further discussion with this agenda item? Well, if not, I'm sorry. Well, if not, thank you again, Kerry. Appreciate the in-depth discussion on this. It brought out a lot of discussion with the board members and I think a lot of clarity, you know, where there's sometimes some cloudiness.
Yeah, we have to, yeah.
We can make copies.
We tried to make, I tried to make the big ones and it wasn't working, but I'll try again.
Especially one with 10. I'd like to be able to look at that. Yeah. But each.
Yeah, we were getting so late on time, I didn't want to read through all of it. I appreciate y'all giving me as much time.
Well, thank you. With that being said, are there any other board comments or requests for future agenda items?
Jack, you want to end this up back? Didn't go tonight? I got to change next week, just scratch it
We don't like paper.
up. It's killer tree.
Then I'll take a
Recycle.
motion. I'm sorry. Then I'll take a motion for adjournment.
Second.